What's up, everybody? And I'm back with part 2 of the state's latest response to Kathleen Zellner's latest filing on behalf of Stephen Avery. I will link part 1 in the description below if you want to go have a view for yourself. So we're going to pick right up where I left off, part C. Stephen Avery's newly discovered evidence claim was multi-layered, requiring application of both Edmonds and Denny. To set aside a judgment of conviction based on newly discovered evidence, the evidence must be sufficient to establish that the defendant's conviction resulted in a manifest injustice. When seeking a new trial based on the allegations of newly discovered evidence, a defendant must establish by clear and convincing evidence that 1. The evidence was discovered after the conviction. 2. The defendant was not negligent in seeking the evidence. 3. The evidence is material to an issue in the case. And 4. The evidence is not merely cumulative. Once those four criteria have been established, the court looks to whether a reasonable probability exists that a different result would be reached in a new trial. I think over anything else, and with everything that has been mentioned, that is a definite possibility, in my opinion. But my opinion does not matter. Here, Stephen Avery claimed that Thomas Sawinski's and apparently Thomas Burrich's later information would permit him to assert a third-party perpetrator defense claiming Bobby Dassey committed the murder. To establish that it is material, then he must have provided sufficient facts to show that it would permit him to meet the legitimate tendency test articulated in the Denny and clarified in State v. Wilson, and to meet the 5th prong of the newly discovered evidence test. I thought there were 3 prongs. I have no idea. He had to provide sufficient facts in this motion to decide a reasonable probability that a jury presented with his third-party perpetrator defense that would have had a reasonable doubt about his guilt. Avery's motion failed to provide sufficient facts that show he could establish either. Thus, the circuit court properly exercised its discretion in denying it. Prior hearing on his Denny claim, Stephen Avery had to provide a sufficient facts to establish the third party had motive, opportunity, and that evidence directly connects them to the perpetration of the crime. Yeah, those are the 3 things. That's what I was talking about. Those are the 3 elements of the test I was talking about. To present evidence that a third party committed the crime for which the defendant is being tried, the defendant must show a legitimate tendency that the third party committed the crime. In other words, that the third party had motive, opportunity, and a direct connection to the crime. A defendant's offer to proof on these 3 prongs is insufficient if it merely establishes a bare possibility that the third party could have been the perpetrator. Number 2, Stephen Avery failed to provide any facts that would establish that Bobby Dassey had motive for the murder. I don't think that's true, but again, it doesn't matter what I think. Motive refers to a person's reason for doing something. Stephen Avery claimed that he pled sufficient facts to establish that Bobby Dassey had a motive to kill the victim because pornography and some gory images were found on the communal computer in the Dassey home. He then claims that the circuit court erroneously required each piece of this evidence to meet all 3 prongs. The record plainly shows that the circuit court did not do that. It examined the evidence he provided for each prong under the test for each prong. That does not seem like it is written correctly. And it reasonably concluded that Stephen Avery did not supply adequate facts to establish that Bobby had a motive to commit this crime. Stephen Avery again claimed that the pornography found on the Dassey home computer established Bobby could have had the sexual motive to commit the murder. The circuit court found that he did not provide any facts to support that speculation. This is because he provided nothing that would establish Bobby conducted the searches for the pornography found on the Dassey communal computer, or that he was even home at the time the searches were conducted. The searches were generic and broad and did not closely resemble anything about this crime. And the two psychological opinions that he submitted were based on assumption that Bobby conducted the searches, which was supported by no facts of record, and were produced without any forensic or psychological examination of Bobby himself. Those findings were all supported by the record and clearly and not clearly erroneous, meaning the circuit court's legal conclusion that Stephen Avery did not plead sufficient facts that could establish Bobby had motive to commit the murder was sound as well. The record shows that Stephen Avery once again failed to supply any facts supporting his contention that Bobby Dassey conducted these searches. As this court noted previously, the mere fact that Bobby could have been home when some of these searches took place fails to establish anything who actually conducted them, and Avery cannot rely on his computer expert, or anyone else's speculation. You can't rely on your experts. Or cannot rely on his computer's experts or anyone else's speculation on what Bobby's schedule might have been on those days, but speculation based on timestamps from a fraction of the searches and some generic statements about the home's occupants. Unusual schedules were once again all Avery provided, with no actual facts about Bobby's whereabouts on the days and times the searches were conducted, nor anyone else's who may have had access to the home. As this court already explained, the existence of the searches is not a fact that would establish Bobby was even in the house at the times, let alone that he was the person using the computer or accessing these images. And Stephen Avery's broad generalizations about whether the other Dassey family members' typical schedules were not sufficient either. Stephen Avery's own submitted exhibit showed that there was no evidentiary support for his allegation that Bobby had a motive to commit this crime. The bulk of the searches for pornography or gory material that Avery relied on to allege motive had no relation to this crime and either occurred on a weekend when anyone could have had access to the computer, or occurred after 3:45 p.m. on a weekday when Blaine indisputably also had access to it. Nor did Stephen Avery account for the fact that the Mishicot School District had spring break from March 24th, 2005 to March 30th, 2005, meaning Blaine and Brendan and anyone else they invited over could have been in the home on weekdays during that time from April 7th, 2006 to April 18th, 2006, meaning Blaine had at least also had access during those weekdays. It's bananas when they say that anyone they invited over. Could you imagine going over to a friend's house and searching that stuff on the alleged family computer? Bonkers. One of the 128 searches listed, only 28 of them occurred between 7 a.m. and 3:45 p.m. on a weekday. Moreover, of those 28 searches, only 3 of them occurred before Teresa Halbach's murder. 2 at 8:14 a.m. on Tuesday, September 13th, 2005, and 1 at 7:45 a.m. on Thursday, September 15th. Even accepting Avery's unsupported speculation that Bobby Dassey was the only person who could have concluded searches during that time frame, Stephen Avery fails to explain how Bobby Dassey's only possible having searched for pornography on a mere 3 times before Teresa Halbach's murder is sufficient to show he was a voraciously violent pornography consumer on October 31st, 2005, who was then spontaneously motivated to abduct and kill a stranger on sight that day because of it. Stephen Avery now claims this was an erroneous finding by the circuit court because several searches took place on September 18th, 2005, which is uncontested. This leads no support to his contention that Bobby was the only person who could have conducted them. However, because September 18th, 2005 was a Sunday, the entire family and any guests they invited over to search porn on the computer. Ooh, that's such a weird. I mean, who knows? Maybe that's a common thing. Maybe people invite friends over to search porn on their computer all the time. I don't know. I can't say I ever invited friends over to watch porn on the computer, on the family computer. The computer they allege was the family computer, the communal computer. This, like, bananas. I lost my spot here. It was a Sunday. The entire family had any guests they would have had been able to perform them. Moreover, to support this contention, Stephen Avery points only to this inadmissible police procedure expert, Greg McCrary's belatedly offered unqualified opinion that Bobby made the September 18th, 2005 searches and that they were evidence of sexual paraphilia. Stephen Avery offered not one shred of factual support for McCrary's statement, nor anything showing McCrary has the relevant credentials to offer it. Indeed, he still fails to point this court to any evidence he submitted to support that statement. Avery failed to support his allegations in his motion with sufficient factual particularity to establish anything related to Bobby Dassey or even to a crime. There was no timestamps given for the searches Avery pointed to in Detective Veal's report, and no explanation of how any of them are relevant to an individual's motive for this murder. Most of them are generic, mundane, and the mere fact that someone searched for news, body, journal, and element doesn't show anything similar or related to this crime. Stephen Avery failed to provide any facts that would even connect the actual pornography searches to anything that occurred here. Someone searching for ghetto sluts, that's what they wrote here, has no relevance to this crime whatsoever. And this court previously observed, despite Avery's insistence that this pornography is similar to what happened to Teresa Halbach in this case. There is no support for this conclusion in the evidence on record. There remains none. Avery once again attempts to rest this theory on, and it lists another case, as if it held that any and all pornography consumption establishes a motive for murder regardless of circumstances. That case held no such thing and is not remotely on point, and as a federal habeas corpus case, it is not law in Wisconsin. The state never argued, nor did the court adopt that Dressler, that's the case, held the pornographic images must be a mirror of the crime or they have no relevance. It correctly determined that to be relevant, the pornography must have some identifiable similarity to the crime, and the facts of the underlying Wisconsin case in Dressler are a vast departure from the facts here. There, the male victim was last seen approaching Dressler's house for a political campaign activity. He was assaulted and murdered in an extremely specific and particularly brutal way that concluded binding, mutilation, and dismemberment. Yee. And police found Madrid weapons, restraints, along with pictures, magazines, and videos depicting similarly murdered and mutilated victims and homosexual pornography in Dressler's home. These items were admitted as other acts of evidence of Dressler's intent, motive, and plan to assault and kill the victim in that particular manner. But in that case, there was no dispute that the materials were Dressler's, unlike in this case, where numerous people could have been responsible for the searches, and Avery has not provided any facts showing otherwise. So, if it shows that, if they talk about how it's possible that multiple people could have conducted those searches on the Dassey home computer, doesn't that show that multiple people could have been responsible for the crime? Maybe. Like, they're talking about how they can't prove it's just Bobby Dassey that did those searches. Okay, sure. But doesn't it prove that it's possible Other people did those searches, which is what they talk about, so it means other people could have possibly committed the crime. Here, however, the searches Avery attempts to rely on vary widely from the obscene to the mundane, with no relation to how Teresa Halbach's murder occurred. Indeed, Avery failed to point to a single image or search for someone who was shot and the body burned, nor anything that would suggest that these widely varying types of pornography had any similarity whatsoever to Teresa Halbach's murder, and he relied on such irrelevant and off-point searches as MySpace, tires, race car accidents, Ford Tempo car accidents, diseased girls, and big women naked. Additionally, in Dressler, there was no dispute that Dressler owned all of the materials before the murder occurred, and that they were deemed relevant to show that he was both homosexual and had fascination with mutilation and dismemberment, and thus formed a motive, intent, and plan to act out his violent sexual fantasies in this particular manner by the time the victim arrived at Dressler's home. Here, the material on which Stephen Avery relied and actually provided some timestamps for had no similarity or relation to how Teresa Halbach's murder occurred, and the vast majority were not made until months after the murder. Avery fails to explain how a motive to fulfill a murderous, porn-fueled sexual fantasy can be formed or proven by someone not seeking or viewing any of this non-similar material until months after the murder had already occurred. To the extent that Dressler is relevant at all, it shows that Avery did not meet his pleading burden, because a comparison to it shows these computer contents would not be admissible to prove motive if Bobby were the defendant. See Wilson, that's another case. Other acts evidence is admissible if it meets the familiar three-part test from State versus Sullivan, requiring it to be offered for permissible purpose, relevant, and that its probative value is not outweighed by unfair prejudice. The later two prongs are not met. Motive is a permissible purpose for introducing other acts evidence, but as explained, none of what Avery presented is relevant to show motive to commit this particular crime. The court already determined that Stephen Avery's contention that these images are similar to the murder of Teresa Halbach were false. The pornography and videos of the murder and mutilation deemed relevant in Dressler were indisputably Dressler's. They closely tracked what happened to the victim in that case and were collected by the defendant long before the murder occurred. Nothing about an unidentified person searching a communal computer for various types of pornography and pictures of race car accidents or drowning victims months after Teresa Halbach's murder occurred shows an interest in anything similar to this crime, nor makes it any more less likely that Bobby Dassey, or anyone else for that matter, had motive to shoot and kill Teresa Halbach. Maybe this was whoever searched its ways of... They committed the crime, and this is their way, allegedly, and this is their way of returning to the scene of the crime. Sure, they live where the crime took place, and that's what the people say. People always return to the scene of the crime, but maybe this is his way of reliving it by looking at pictures, by watching videos, or whatever it was that was searched on the computer. This is their way of reliving it even more in reality to them. Drowning victims months after Teresa Halbach's murder occurred shows any interest in anything similar to this crime, nor makes it any more or less likely that Bobby Dassey, or anyone else for that matter, had motive to shoot and kill Teresa Halbach in October 2005. The computer contents are simply not relevant. These searches and images would be excluded as other acts evidence because without some closer tie to the events of October 31st, 2005, their prejudicial value would greatly outweigh whatever minimal relevance they might have and influence the jury to convict because they believed whomever conducted the distasteful searches must be a bad person. Avery's claim that the circuit court ignored Stephen Avery's evidence of Dassey computer deletions, which infers consciousness of guilt, similarly reflects on no foundation. Avery offered nothing showing how or who made any deletions or why they mattered. He again simply relied on his unfounded claims that this pornography closely resembled this crime, which this court previously found from facts and an unsupported contention that Bobby Dassey was responsible for deleting it. Avery's insistence that these deletions were made by Bobby and show consciousness of guilt is as usual no more supported than guesswork grounded in presuming the conclusion. Stephen Avery provided no facts to prove it. Law enforcement were seeking evidence of motive, among other things, in their search warrant affidavit cannot carry the load Avery assigns it either. Police seizing and analyzing the computer, seeking evidence of motive, does not mean that anything they found ipso facto is evidence of motive, and Avery appears to believe. Law enforcement investigating a murder search for anything that could conceivably be relevant to the case. Vast portions of what the police collect is later determined to be of no importance. Stephen Avery's contention that law enforcement's reporting about this pornography means the pornography's mere existence establishes that Bobby had a motive to commit the crime is pure speculation, which Avery did not factually connect to Bobby Dassey or show any similarity to this crime with any evidence at all. Alright, that's where I'm going to leave part 2. I'll be right back with part 3, and I think that will be the final part of this filing. What do you think of everything so far? Let me know. Leave some comments below. I hope you're having a good day, and I will see you again soon.